Hi, I'm Brad Rowe, criminal defense attorney with Rowe Law Group in Pensacola. Today, let's talk about the differences between DUI and a BUI in Florida. Two people, two drinks, one's behind the wheel of a car and the other at the helm of a boat, and both get stopped. And in Florida, one faces a DUI and the other a BUI. People assume they're the same charge just with a different vehicle, and that's not true. And in July 2025, one of the biggest differences between them flipped. So DUI is governed by the Florida Motor Vehicle Code and BUI, separate statute under the Vessel Code. Now under both, the state proves impairment either by your normal faculties being impaired or by a blood alcohol concentration of 0.08 or higher. Same number, same structure, one applies to a vehicle and the other a vessel. And vessel is broad. It essentially means any watercraft on all waters in the state of Florida. So for years, there was a sharp distinction between a DUI and a BUI. To pull your car over, an officer generally needs reasonable suspicion, but on the water, officers, including FWC, could stop and board almost any vessel for a routine safety inspection. No suspicion required. That was a real gap in your Fourth Amendment protection. And that changed about this time last year with Florida Boater Freedom Act, prohibiting an officer from stopping or boarding a vessel without probable cause. No more random safety inspection stops. In place of them, the state created voluntary Florida Freedom Boater decals that shows your vessel meets the equipment requirements. So the water now looks a lot more like the road. Officers still need a real reason. Reckless operation, an observed violation, genuine probable cause before they can stop you. And that opens up a stop challenge on the water that frankly didn't exist before. Even after a valid stop, the testing is different. Field sobriety exercises were designed for solid level ground. Put that same person on a rocking deck after a day of sun, heat, wind, red eyes, poor balance, a flushed face can be impairment, or just what 8 hours on the water does to a sober person. That overlap is one of the strongest defenses in a BUI case. And criminally, the penalties track pretty closely with each other. A first offense can mean up to 6 months in jail with enhancements if you're over a 0.15, a minor on board, or if there's serious injury. A DUI arrest still triggers a separate DMV case to suspend your driver's license, and you have just 10 days to demand a hearing to fight that. A standard BUI does not suspend your driver's license at all. That's one key difference. And Florida cross-counts DUI convictions and BUI convictions. So what does that mean? So someone with 2 prior DUIs and a first ever BUI can face felony level enhancement charges. The law treats a drunk boat and a drunk car as essentially the same underlying problem. Same 0.08, same normal faculties language, but very different cases, and the rules shifted. I'm Brad Rowe, and if you're facing charges in Northwest Florida, call me. The number's on the screen.